2. Rights and duties of members. A. Rights of member. Section number 22A. A member shall be entitled to exercise such rights as provided in the Act, rules, and bylaws, provided that no member shall exercise the rights of member of a society until he has made such payment to the society in respect of membership or acquired such interest in the society. B. Provided further that, in case of increase in minimum contribution of member in share capital to exercise right of membership, the society shall give a due notice of demand to the members and give reasonable period of time to comply with. Active member. C. A member shall be termed as an active member if he or she fulfill the following conditions, viz. 1. He or she has attended at least one general body meeting in previous consecutive period of 5 years, provided that nothing in this clause shall apply to the member whose absence has been condoned by the general body meeting of the society. 2. He or she has purchased and owns flat or unit in the society. And 3. He or she has paid the society maintenance service and other charges regularly. D. A member who is not an active member shall be non-active member. E. Society shall classify the members as active or non-active member at the close of every financial year. 1. Society shall communicate to every non-active member about his classification within a period of 30 days from 31st March of every year, as prescribed under these bylaws as per Appendix 2. In case of a dispute about classification of a member being active or non-active, an appeal shall lie with the registrar within a period of 60 days from the date of communication of such classification. F. A non-active member can be reclassified as active member from the date he satisfies the conditions laid down under Bylaw number 22C. B. Getting copy of the bylaws, audit report, AMP inspection of books, AMP records, and getting copies thereof. Section number 23A. A member shall have right to inspect free of cost books, registers, documents, etc., as provided in Section 32(1) of the Act, and get copies of the documents as provided under Section 32(2) of the Act, on payment of the fees prescribed under the bylaw number 172. B. A member shall be entitled to receive a copy of the approved bylaws, audit report of the society, on payment of charges prescribed thereof. C. Occupation of flats. Section number 24A. The member who is deemed to have been allotted the flat under the bylaw number 76A of the society shall have a right to occupy the flat subject to the terms and conditions set out in the letter in the prescribed form under the said bylaw. B. The associate nominal member may have a right to occupy the flat with the consent of the member and written intimation to the society, subject to the conditions set out by the general body meeting. D. Restrictions on rights of associate and nominal members. Section number 25. No associate member shall have any rights or privileges of an active member except as provided under Section 27(2) of the Act, and he fulfills the conditions of Bylaw 22A. Section number 26. A nominal member shall have no rights, such as member. E. Resignation of membership. 1. Resignation by a member. Section number 27. A. A member may resign from membership after giving 3 months' notice in the prescribed form to the Secretary of the Society as provided under Rule 21(1) of the Rules. B. No resignation of a member of the Society shall be accepted unless such member has made payment of the charges payable to the Society in full. C. Where any charges are found payable by the member to the Society, the Secretary of the Society shall intimate the same, giving full details and reasons of dues thereof to the member within 15 days of the receipt of the notice of resignation, advising him to make payment thereof within 30 days of the date of intimation. D. Where there are no charges of the Society outstanding with the member, the committee shall accept the resignation of the member, and the Secretary of the Society shall communicate the same to the member within a period of 3 months from the date of the receipt of the notice of the resignation. Deferung, resignation by an associate member, section number 28. An associate member may resign his membership any time by writing the letter of resignation to the Secretary of the Society through the member with whom he held the shares of the Society jointly. The Secretary of the Society shall place the letter of the resignation of the associate member before the meeting of the committee, held next after the receipt of the letter of the resignation, duly recommended by the member for acceptance by the committee. The decision of the committee accepting the resignation of the associate member shall be communicated by the Secretary of the Society to the member and his associate member within 15 days of the decision by the committee. If the resignation is rejected, the committee shall record the reasons therefor in the minutes of its meeting, and the Secretary shall communicate the same to the member and his associate member within the time specified above. 3. Resignation by a nominal member occupying the flat on behalf of the firm, company, or any other body. Corporate section number 28. If there is a nominal member occupying the flat on behalf of a firm, company, or any other body corporate, he or she may resign his nominal membership at any time by writing the letter of the resignation to the Secretary of the Society through the firm, the company, or any other body corporate on whose behalf he is occupying the flat. The Secretary of the Society shall place the letter of resignation before the meeting of the committee, held next after the receipt of the letter of the resignation of the nominal member, duly recommended by the firm, the company, or any other body corporate, for acceptance by the committee. The decision of the committee accepting the resignation shall be communicated by the Secretary of the Society to the firm, company, or the body corporate and the nominal member within 15 days of the decision by the committee. If the resignation is rejected, the committee shall record reasons therefor in the minutes of its meeting, and the Secretary shall communicate the same to the firm, company, or the body corporate and the nominal member within the time specified above. 4. Resignation by a nominal member who is sublettee, licensee, caretaker, etc. Section number 29. A subletter, licensee, caretaker, or possessor of a flat or part thereof, who has been admitted as a nominal member of the Society, may resign his nominal membership at any time by writing the letter of the resignation to the Secretary of the Society through the member who has been permitted by the committee to sublet, give on leave, and license or caretaker basis the flat or part thereof, or part with its possession in any other manner. The Secretary of the Society shall place the letter of the resignation before the meeting of the committee, held next after the receipt of the letter of the resignation, duly recommended by the member concerned for acceptance by the committee. The decision of the committee accepting the resignation shall be communicated by the Secretary of the Society to the member concerned, and his sublettee, the licensee, the caretaker, or as the case may be, the possessor of the flat or part thereof, within 15 days of the decision by the committee. If the resignation is rejected, the committee shall record reasons therefor in the minutes of its meeting, and the Secretary of the Society shall communicate the same to the member concerned, and his sublettee, licensee, or caretaker, etc., within the time specified above. Section number 30. On acceptance of the resignation of the member, under Bylaw number 27, the Society shall acquire the shares and interest of the member in the capital/property of the Society and pay him the value thereof, as provided under the Bylaw number 66. G. Nomination by members. Section number 31. A member and/or associate member of the Society may, by writing under his hand, in the prescribed form, nominate a person or persons to whom the whole or part of the shares and/or interest of the member in the capital or property of the Society shall be transferred in the event of his death. The acknowledgement of the nomination by the Secretary shall be deemed to be the acceptance of nomination by the Secretary. No fees shall be charged for recording the first nomination. A member may revoke or revise his nomination at any time by making an application, in writing under his hand, to to the Secretary of the Society. The acknowledgement of the variation in nomination or subsequent nomination by the Secretary shall be deemed to be the cancellation of earlier nomination. Every revision of the nomination shall be charged a fee of Rs. 100 Section number 32. On receipt of the nomination form, or the letter for revocation of the earlier nomination, the same shall be placed before the meeting of the committee, held next after the receipt of the nomination form, or the letter of revocation of the earlier nomination, by the Secretary of the Society, for recording the same in the minutes of the committee. Every such nomination or revocation thereof shall be entered in the Register of Nominations by the Secretary of the Society within 7 days of the meeting of the committee in which it was recorded. Section number 33, subject to the provisions of the Section 30 of MCS Act 1960 Bylaw number 17A or 19. On the death of a member, the Society shall transfer the shares and interest of the deceased member in the capital or property of the Society to the nominee or nominees, and in proportion with the shares and interest held by the deceased member, in case property is purchased by member and associate member jointly. In the event of death of the member, nominee or nominees shall submit the application for membership within 6 months from the death of a member. If there are more than one nominee on the death of a member, such nominees shall make joint application to the Society and indicate the name of the nominee who should be enrolled as member. The other nominees shall be enrolled as joint or associate members unless the nominees indicate otherwise. The nominees shall also file an indemnity bond in the prescribed form, indemnifying the Society against any claims made to the shares and interest of the deceased member in the capital or property of the Society by any of them, in case only one nominee is indicated by the nominees for membership of the Society. Note: in case of acquiring membership on the basis of nomination, such member shall hold the flat or unit in trust till all the legal heirs are brought on record, and shall not have the right to ownership, and shall not create third-party interest or alienation in any way whatsoever. Section number 34. Transfer of shares and interest of the deceased member in the capital or property, OTF the Society to the heir. Where a member of the Society dies without making a nomination, or no nominee comes forward for transfer, the Society shall invite within 6 months from the information of his death claims or objections to the proposed transfer of shares and interest of the deceased member in the capital or property of the Society by a public notice in the prescribed form exhibited on the notice board of the Society. It shall also publish such notice in at least 2 local newspapers having wide circulation. The entire expenses of publication of the notice shall be recoverable from the value of shares and interest of the deceased member in the capital or property of the Society. After taking into consideration the claims or objections received in response to the said notice, and after making such inquiries as the committee considers proper in the circumstances prevailing, the committee shall decide as to the person who, in its opinion, is the heir or legal representative of the deceased member. Such a person will be eligible to be a member of the Society subject to the provisions of the bylaws numbers 17A or 19, provided that he gives an indemnity bond along with his application for membership in the prescribed form, indemnifying the Society against any claims made to the shares and interest of the deceased member in the capital or property of the Society at any time in future by any person. If there are more claimants than one, they shall be asked to make the affidavit as to who should become a member of the Society, and such person, named in the affidavit, shall furnish the indemnity bond as indicated above, along with application for membership referred to above. If, however, the committee is not able to decide as to the person who is the heir or legal representative of the deceased member, or the claimants do not come to the agreement as to who should become the member of the Society, the committee shall call upon them to produce succession certificate from the competent court. If, however, there is no claimant, the shares and interest of the deceased member in the capital or property of the society shall vest in the society. Section number 35. Payment of the value of shares and interest of the deceased member in the capital, or if there is the single nominee, and if he demands payment of the value of shares and interest of the deceased member in the capital or property of the society shall acquire the same and pay him the value thereof as provided under the bylaw number 63. If, however, there are more nominees than one, and if they demand payment of the value of the shares and interest of the deceased member in the capital or property of the society shall acquire the same and pay them value thereof, as provided under the bylaw referred to above, in the proportion mentioned in the nomination form. If no proportion is mentioned in the nomination form, the payment shall be in equal proportions. Section number 36. Payment of the value of shares and interest of the deceased member in the capital or property of the society to the heir or legal representative. If, in the opinion of the committee, there is only one heir or legal representative of the deceased member, and if he demands payment of the value of the shares and interest of the deceased member in the capital or property of the society may acquire the same and pay him the value thereof, as provided under the bylaw number 63, after obtaining the indemnity bond referred to in the bylaw number 34. If, in the opinion of the committee, there are more heirs or legal representatives than one, and if they demand payment of the value of shares and interest of the deceased member in the capital or property of the society may acquire the same and pay them value thereof in equal proportion, as provided under the bylaw number 66, after obtaining the indemnity bond referred to in the bylaw number 35, from all the heirs or legal representatives jointly. H. Transfer of shares and interest in the capital or property of the society. Section number 37. Notice of transfer of shares and interest in the capital or property of the society. A member desiring to transfer his shares and interest in the capital or property of the society shall give 15 days' notice of his intention to do so to the Secretary of the Society in the prescribed form, along with the consent of the proposed transferee in the prescribed form. B. On receipt of such notice, the Secretary of the Society shall place the same before the meeting of the committee, held next after the receipt of the notice, pointing out whether the member is prima facie eligible to transfer his shares and interest in the capital or property of the society, in view of the provisions of Section 29, 2a of the Act. C. In the event of ineligibility, in view of the provisions of Section 29, 2a and b of the Act, of the member to transfer his shares and interest in the capital or property of the society, the committee shall direct the Secretary of the Society to inform the member accordingly within 8 days of the decision of the committee. D. No objection certificate of the society is not required to transfer the shares and interest of the transferor to transferee. However, in case such a certificate is required by the transferor or transferee, he shall apply to the Society, and committee of the Society may consider such application on merit within 1 month. The transferor or transferee shall submit following documents and fulfill compliance as under: 1 application in the prescribed form for transfer of his shares and interest in the capital or property of the Society, along with the share certificate. 2 application in the prescribed form for membership of the proposed transferee. 3 resignation in the prescribed form, member or transferor. 4 registered agreement with stamp duty paid. 5 valid reasons for the proposed transfer. 6 undertaking to discharge all the liabilities to the society by transferor. 7 payment of the transfer fee of Rs 508, remittance of entrance fee of Rs 100 payable by the proposed transferee. 9 payment of amount of premium at the rate to be fixed by the general body meeting, but within the limits as prescribed under the circular issued by the Department of Cooperation or Government of Maharashtra from time to time. No additional amount towards donation or contribution to any other funds or under any other pretext shall be recovered from transferor or transferee. 10. Submission of no objection certificate required under any law for the time being in force or order or sanction issued by the government, any financing agency, or any other authority. 11. The undertaking or declaration in compliance with the provisions of any law for the time being in force, in such form as is prescribed under these bylaws. Note: the condition at SR number 9 above shall not apply to transfers of shares and interest of the transferor in the capital or property of the society to the member of his family or to his nominee or his heir or legal representative after his death, and in case of mutual exchange of flats amongst the members. Section number 38. Disposal of transfer applications. A. The procedure for disposal of applications for transfers of shares and or interest of members in the capital or property of the society, as laid down under the bylaw number 62, shall be followed by the Secretary and the Committee of the Society. Committee or general body not to ordinarily refuse any application for membership or transfer of shares. B. A meeting of the committee or the general body, as the case may be, shall not refuse any application for admission to membership of transfer of shares and interest in the capital or property of the society, except on the ground of non-compliance of the provisions of the Act, the rules, and the bylaws of the society, or any other law or order issued by the government in exercise of the statutory powers vested in it, deemed to have been admitted, if not communicated within 3 months. C. If the decision of the committee or general body meeting, as the case may be, on the application for transfer of shares and/or interest in the capital or property of the society is not communicated to the applicant within 3 months of its receipt, the transfer application shall be deemed to have been accepted, and the transferee shall be deemed to have been admitted as a member of the society as provided under Section 22(2) of the Act. Unauthorized transfer void. D. Any transfer made in contravention of the Act, rules, or the bylaws shall be void and not effective against the society. Section number 39. Rights of membership when to be exercised by the transferee. The transferee shall be eligible to exercise the rights of membership on receipt of the letter in the prescribed form from the society or order under Section 22 or 23 of the Act from the registrar, subject to the provisions of the MCS Act 1960, rules and bylaws. I. Exchange of flats. Section number 40. Application for exchange of flats by the members of the members desiring to exchange their flats shall make a joint application to the Secretary of the Society containing the following details. A. The names of the members concerned. B. The distinctive numbers of their respective flats. C. The carpet areas, in square meters, of their respective flats. D. The building number or numbers or names of the building or buildings in which the respective flats are situated. E. The reasons for exchange of flats. Section number 41. Disposal of applications for exchanges of flats by members. The procedure for disposal of applications for exchanges of flats, as indicated in the bylaw number 62, shall be followed by the Secretary and the Committee of the Society. J. Subletting, etc. of flats. Section number 42. Subletting, etc. Not permissible except under the Society's permission. 1. A member shall intimate to the Society of subletting his flat or giving on leave and license basis or caretaker basis or parting with its possession in any other manner. However, the member shall submit a copy of leave and license agreement and copy of intimation report to the police station. Application for permission to sublet, etc. 2. No permission of the Society is required to sublet the flat or shop. However, the intimation needs to be given to the Society 8 days before such subletting. Section number 43. Restrictions on assignment of occupancy right in the flat. No member of the society shall assign, mortgage, or create any charge on his occupancy right in the flat without the previous permission in writing of the society, provided that such permission of the society will not be required for assigning, mortgaging, or creating any charge on the occupancy right in the flat for the purpose of obtaining loan, either for purchase of the flat or for liquidating the liability incurred by him for the said purpose by way of loan or advance from the employer or the member or from the Life Insurance Corporation of India or from a bank or the society or any other agency approved by the Commissioner for Cooperation and Registrar, CSMS Pune. For more information, log on to www.societyexplore.com.